मुस्लिम कम्युनिटी का यह कहना था आप साहबानों को जस्टिस दे देते कोई बात नहीं, मगर कुरान को इंटरप्रेट नहीं करनी थी। 5 नॉन मुस्लिम जजेस। नमस्कार, वेलकम to important Supreme Court Judgment Series episode 4. Today we are going to discuss an important landmark judgment where Supreme Court desired to resolve a conflict, but unfortunately the case itself became a region of conflict. Yes, we are talking about Sahabano Begum case 1985. This was such a unique incident where the intention was to give justice to a Muslim woman, but ultimately the country landed in a serious situation of religious fundamentalism. Just like all other episodes, we will not only discuss the judgment but also the factors that led to the judgment and its profound impact on our society. Let us check out. But before the main course, here is the starter. You know, in our country there is equality of law. Means for our constitution, we all people are equal. But there is an exception. As far as family matters are concerned, example marriage, divorce, maintenance, inheritance, there are different laws for different religions. They are called personal laws. Example, Hindu Marriage Act 1955, Parsi Marriage and Divorce Act 1936. These are personal laws. According to Muslim personal law, a marriage gift is given to bride which is called meher ka rakam. The amount is settled before marriage, but payment is usually done later when marriage either dissolves or husband dies. The cause of whole story of Sahabano case was nothing but this meher ka rakam. Now listen very carefully about these two important concepts. Section 125 of Criminal Procedure Code 1973 says, if a husband gives divorce to his wife, a magistrate can order him to provide monthly allowance to the divorced wife if she is unable to maintain herself. इसका मतलब यह है कि अगर हस्बैंड वाइफ को डिवोर्स देता है और वाइफ फाइनेंशियली इंडिपेंडेंट नहीं है तो मैजिस्ट्रेट हस्बैंड को मंथली अलाउंस पे करने के लिए ऑर्डर कर सकते हैं. एंड सेक्शन 127 सेज इफ वाइफ इज ऑलरेडी पेड डिवोर्स मनी अंडर पर्सनल लॉ, ऑर्डर पास्ड अंडर सेक्शन 125 इज कैंसल्ड. मतलब अगर पर्सनल लॉ के वजह से वाइफ को ऑलरेडी डिवोर्स पेमेंट मिल चुकी है तो सेक्शन 125 एप्लीकेबल नहीं है. कॉन्सेप्ट इज वेरी सिंपल. Either you take monthly alimony from husband under section 125, else take money according to your own personal law, but not both. Now comes the most important question. What if the divorce payment under personal law is inadequate? Can we force a woman to remain satisfied with that insufficient amount and reject her claim under section 125? The answer lies in Sahabano case. Now what is this Sahabano case? थोड़ी background story समझते हैं. In 1978, a Muslim lawyer, Mr. Muhammad Ahmad Khan, divorced his wife Sahabano by triple talaq and he paid only 3,000 rupees as meher ka rakam. Only 3,000 rupees was not sufficient amount for lifetime. Hence, Sahabano filed a petition under section 125 in Indore and asked for maintenance. Magistrate of Indore ordered her husband to pay rupees 25 per month to Sahabano. Only 25 rupees. Sahabano was not happy with this amount. She appealed in High Court where the value was revised to around 179 rupees. Now Mr. Ahmad Khan was not happy with this judgment. He appealed in Supreme Court against High Court decision. Hence remember, Sahabano did not go to Supreme Court. Today we are learning this judgment thanks to his husband. He went to Supreme Court. Supreme Court took this case very seriously and constituted a 5-judge bench. Interesting fact is that 4 among them were Hindus and 1 was having no affiliation with any religion. Supreme Court asked 2 questions. First, every husband has some duty towards his wife. Just by paying a bare minimum meher ka rakam, can a husband discharge himself from his duty? How a wife will survive if the meher amount is too less? Muslim personal law failed to address this question. If personal law don't address a situation, then definitely judiciary will address. What judiciary have? Judiciary have section 125, which is applicable to all religions, including Muslims. Hence, final answer is, in case any conflict between section 125 and personal law occurs, section 125 will prevail. Second question. After all, what is meher? It is a payment in consideration of marriage. Just because it is paid after divorce, we cannot say it is divorce payment. Hence, meher is not divorce payment. Hence, in spite of meher payment, court can order husband for maintenance. Court even interpreted Quran and told husband is duty bound to maintain his wife. Hence, court upheld the Madhya Pradesh High Court decision and ordered the husband to pay alimony. Whenever Supreme Court takes any judgment regarding religious matter, we know how sensitive the issue becomes. Recently, we have seen in Triple Talaq case. Sahabano case was no exception. The judgment got significant attention from media and civil society. Sensational press coverage and aggressive protest was obvious. It created a conflict not only between Hindu and Muslims but also among Muslims. Conservative Muslims and liberal Muslims got divided in their opinions. Basically, there were 4 points critics had. First, मुस्लिम कम्युनिटी का ये कहना था आप साहबानों को जस्टिस दे देते कोई बात नहीं, मगर कुरान को इंटरप्रेट नहीं करनी थी. 5 non-Muslim judges interpreted Quran. It is a disrespect to our Muslim scholars. You could have simply given justice based on constitutional principle. Second, it is not just a maintenance judgment. Rather, it is an insult to Muslim law, Islamic practices, and its treatment of women. Third, Muslims also thought the country is absorbing them into mainstream Hindu society. They started questioning country's commitment to pluralism. And finally, the fourth, until this case, Muslims were willing to consider Uniform Civil Code. What is Uniform Civil Code? It is nothing but uniform laws applicable to all religion. But after the Sahabano judgment, they became a little bit skeptical. They thought UCC code may be dominated by majorities code, means Hindu code. You think all this disturbance is painful? No. Even more painful issue is that Sahabano came under tremendous pressure and withdrew the maintenance claim she had filed. She put her fingerprint on a paper saying that she has no association with this judgment. The story does not end here. Whenever Hindu-Muslim conflict arises, it puts significant impact on political atmosphere of our country. Hence, Rajiv Gandhi government, which initially supported the judgment due to huge pressure, passed Muslim Women Protection of Rights in Divorce Act 1986, also called MWA. Now, Muslim women were not happy. There were basically 2 reasons. First, there were many provisions inserted in this act which somewhat nullified the court judgment. And second, just to satisfy few conservative Muslims, how Parliament can pass a law for all Muslims? This act even catalyzed right-wing Hindutva movement which later led to Babri Masjid demolition in 1992, which further resulted riots which further caused 1993 bomb blast in Mumbai. Scholars say MWA was cause of all these incidents. There were many petitions against MWA, but instead of striking down completely, Supreme Court interpreted MWA in such a manner it can truly protect Muslim women. Hence, now what is the status? Currently, a divorced Muslim wife can file a petition either under section 125 of CRPC, which is recurring payment, or a lump sum settlement under MWA. This is how the story unfolded, becoming an ugly collision between women's right and religious belief. Supreme Court desired to give justice, but Sahabano did not claim alimony. But we hope in future no other Sahabano should go through all this mental trauma. What is your opinion about this? Does our constitution has enough safeguards to protect women in our society? Can our society protect women who suffer during religious conflicts? Please be a participative student and drop in the comment section. I hope the video was insightful. Don't forget to like and subscribe. I am Omkar signing out. Till we meet next time. Bye bye.